I think we can start now.
We'll start with video or straight start with the
No, we can
presentation?
start. We can
Straight
start.
away?
Now.
Okay.
Yeah.
Are we live already?
Yes, we are live.
Okay. Hi, everyone. Good afternoon, good evening, whichever way we take it. But this is yet another round of Shastrarth on this very important subject, which is Digital Personal Data Protection Bill, soon to become Act. It's been passed by both the houses. Presidential assent is awaited. And thereafter, before the full roll down of the law, there might be still several months because a lot of subordinate legislation is still to follow, even the ecosystem, including the essential agencies, for example, the Data Protection Board, the appellate bodies, etc., will still take some time to get created. However, it's important for all lenders to get aware of what does the law mean for them. Let me first start by saying that this law has various repercussions for various people. It might be impacting a lot of people in different ways, but our focus today will be entirely on the lenders. And there again, with a special focus on digital lenders, lenders of all types, but specifically on digital lenders. Of course, it's a matter of common knowledge that since the Supreme Court ruling in 2018 till 2023, the bill has passed a long phase of a work in progress. In the meantime, 137 countries have enacted similar laws, and we are the 138th country to recognize that privacy of data is, after all, a very important part of our fundamental rights. And nevertheless, India is an extremely fastly digitized country, and therefore we cannot afford to take any steps which might be counterproductive, counter-developmental. So balancing the needs of a digital economy, balancing the needs of a fast-growing financial sector, at the same time also safeguarding the customers, the consumers' privacy. These considerations have been balanced by this law. This law is a lot softer than the 2022 version, as my colleagues will later on explain. But let me just first get started by quickly giving a flavor of what the law contains. So I'll start by giving a quick overview of the contents of the bill. And let's get started with what are the major sections which might be of relevance to lenders. I would say section 4, 5, 6, 7, 8. These are important sections that are operative provisions of the law. Section 11 to 15 relate to duties and liabilities, more the rights, but less one section dealing with duties of data principles. And then section 17 becomes quite important, but that's what is dealing with so-called legitimate uses. And section 17 has a direct relevance to financial entities. One part is dealing directly with financial institutions as a part of section 17. So dealing with section 4, 5, 6, 7, 8, very, very quick overview. Section 4 says that you can use data of someone, digital data. The stress of entirely is on digital data because it's digital data which is the focal point of the law. The law itself is called protection of digital personal data. The data is personal, the data is digital. That's where the law comes into play. So uses of processing of personal data, of digital personal data of an individual can be done only in two ways. Number one, based on a consent. That's the first important part. The data principal, the person who is the owner of the data, must have explicitly consented to the use of the data. That's part one. Alternatively, it can be used for certain legitimate uses. So there are two ways: legitimate uses and a consent-based uses of data. Legitimate uses goes and reads with section 7, to which I'll come back to later. As far as the first part, namely explicit consent is concerned, the consent requires once again two things. Number one, notice, which is dealt with by section 5. Section 5 talks about what is the manner of giving the notice, etc. And then comes second part, which is section 6. It talks about the consent, and it uses some very qualifying words which are very significant though, but they are more like, I would say, generic as well as significant. The consent should be free, it should be specific, it should be informed, it should be unconditional, unambiguous. That ambiguous consent, for example, a cookie policy, that wouldn't be taken to, probably not. My colleagues will speak further on that. But the consent has to be completely unambiguous, specific, free, informed, and unconditional. That's section 4, 5, 6. Therefore, read as a kind of combination. And each of them, but section 4, 1A, read with section 5 and 6 talks about the consent-based uses of data. Then comes section 7, which is very important for financial entities. In fact, for every entity, because 7A, 7 has several sub pieces, but we will be concerned here with 7A because BCD, etc., are instrumentalities of the state, judicial bodies, regulatory bodies, and so on. Let's be focused on 7A. And to an extent, we will be concerned with, I think, 7A primarily, but let's maybe think if there's anything else in section 7 which is of relevant. Section 7A says, that's going back to section 4B, which was talking about legitimate uses. And that's where section 7A says that legitimate uses includes the following. And part A says, if the data has been given voluntarily, somebody is voluntarily given data in respect of which she is not withdrawn or does not consent to use your personal data, voluntarily given personal data to data fiduciary for the specific purpose, that is, as long as I'm using the data for the purpose for which the data was given, that will still be a legitimate use. I don't need to bother about a consent in that case because the data is being used precisely for the purpose for which the data was given. Now, there'll be, of course, a lot of discussion around that in context of lenders. For example, a borrower comes to me, gives the data for the purpose of processing a loan. Well, I surely can use the data for the purpose of giving a loan. But can I use it for selling an insurance policy to the very borrower? And if that is the uses, the cross-marketing I'm trying to think of, the question would be, does that require a notice or a consent, to which my colleagues will allude to as we process further. That is section 4, 5, 6, 7. Like I mentioned, these are very important sections. And then obligations of the fiduciary incorporated in section 8. The moment you have someone's data, you become the fiduciary. And the moment you become fiduciary, there'll be a question of obligations of the fiduciary, the so-called general obligations. You can process the data either by yourself or on its behalf by a processor. The moment you use the word on your behalf, meaning the data processor is acting as your agent, because that would mean on behalf, meaning there's an agency relationship. Fiduciary is the one who is primarily responsible. The processor becomes an agent of the fiduciary. Think in terms of lending transactions once again. If a lender, you engaged a so-called loan sourcing, any kind of a loan sourcing partner, loan sourcing or servicing partner, and you are letting the data be used by the so-called LSP, the LSP becomes a data processor, but the obligation of ensuring adherence to provisions of the law will primarily rest on the fiduciary still. And a fiduciary may engage a processor only for goods or services. That is, the contract involves goods or services, and that too under a valid contract. Valid contract meaning there needs to be a valid contract between the fiduciary and the processor. And then it talks about some other obligations of the data fiduciary, which are, of course, significant. It also talks about a consent manager. Now, that's a consent, this kind of an institution, which I imagine will be arising under the law, a sort of an entity through whom the consents can be routed. And therefore, a data principal may give consent either directly to a fiduciary or through a consent manager. We'll talk about the consent manager later as we proceed. Once the purpose for which data was given is over, in that case, the data principal, data fiduciary will have to erase the data. And that's one of the general obligations of the fiduciary. That's also a very important obligation. That brings us to the rights and obligations of the data principal. Much of this is pure common sense. And these are, of course, contained in sections 11, 12, 13, 14, right up to section 15. 15 talks about duties. I wouldn't spend much time on these because these might not be so very relevant to what we have to discuss. Just that, if at all, one data fiduciary is providing the data to another data fiduciary, circumstances in which data fiduciary parts with or shares the data, not with a processor, but another data fiduciary. Data can be given to a processor or data can be given to a data fiduciary. But if the data fiduciary is given the data to another DF or data fiduciary, this also must be a part of the explicit consent of the data principal, or the so-called legitimate uses must surely imply the giving of data to a data fiduciary, another data fiduciary as well. So there again, we'll have to read section 4A and 4B whether the giving of data to another data fiduciary was a part of either explicit consent or can be taken to be part of the so-called legitimate use. So that was section 11, 12, 13, 14, 15. 15 is talking about duties of data principle, which are also quite common sense duties. That brings me to section 17. And that talks about the processing of data is necessary for enforcing legal rights. So it's saying the provisions of chapter 2 except subsection 8, 1 and 8 by 1 and 5 shall not apply. That the entire section 4 to 7 shall not be applicable in case of data processing which is required for enforcing any legal right or a claim. I'm sure in context of financial institutions, you can easily understand that for the purpose of enforcing a claim, if I have to pass the data to some, let's say to data recovery agency. So that's very clear that this data is this data processing is required for enforcing a legal right or a claim. That's part one. And then the other part, which is very significant, is 7.1F, which talks about 17.1F, which talks about processing of the data is required for the purpose of in the event of a default. If default is occurred, processing is for the purpose of ascertaining financial information and assets and liabilities of any person who has defaulted. So if at all I part with the information in the event of a default and I'm trying to ascertain the financial position or the assets and liabilities of a borrower, for example, who is defaulted to a financial institution, the word default is defined with reference to IBC. A financial institution is also defined with reference to IBC. Financial institution as defined in IBC includes NBFCs as well. So banks as well as NBFCs, both are captured by definition of financial institution. So that is broadly the construct of the law. This was, I would say, general overview of the law, but let's move to specifics. And let me move to my colleagues Abhirup Ghosh and Shubhajit Shom, who are going to give us a Gyan. And let's start with the so-called Gyan question first. The first question I would need to ask Abhirup. As Abhirup, I think all the participants here are eager to know in what way does the bill affect lenders, particularly digital lenders. I think you can start with digital lenders first and then say, what about other lenders who are not into digital lending? Does the law, or in what way does the law concern them? Let's start with Abhirup first. Abhirup.
Right. Thank you. So, as you just mentioned some time back that this law will be applicable to any person having access to digital data and who would want to process the digital data for a commercial gain would fall under this particular law. So lenders having access to personal data, I mean, they have personal data, they use personal data for various functions, for customer profiling, for loan sanction, loan monitoring, servicing. So all these quite naturally, makes lenders, I mean, data fiduciary under this law. Now, coming specific to this question, so I can address this question in two parts. First, I'll talk about digital lenders. Now, digital lenders, who are digital lenders? They usually are so lenders who are carrying out most of their lending functions through a digital platform. So, I mean, a loan might involve multiple functions, starting from loan sourcing to disbursement to collection, monitoring, servicing. Everything forms part of, I mean, all these functions together makes a loan transaction. So a lender who is carrying out majority of the functions digitally would be called as digital lender. And quite naturally, since they are accessing the information digitally and they are also processing the data digitally, so quite naturally they are data fiduciaries. Now, when it comes to normal lender or non-digital lenders, let's say, now, we will have to look, I mean, take a closer look at the language of the law. So this law applies where the data has been acquired digitally or it has been acquired non-digitally, but subsequently digitized. So it actually is not emphasizing on the way or the manner in which the data has been collected. The emphasis is more on the way the data has been processed. So are we processing the data digitally? And if we look at the definition of processing, it is pretty wide. So right from analyzing the data to storing the data, everything would fall within the purview of processing. So, and as on date, we will hardly find any lender who's not using IT tools or computer for storing or processing of data, even if it is collected physically. So, therefore, in that sense, even non-digital lenders would also become data fiduciaries for the purpose of this law.
Are you therefore saying that if the data is stored digitally, which would inevitably always be the case,
Yeah.
then even a non-digital lender is within the framework of the law?
Yes. Yes.
Shubhajit, I would just extend this question and ask you in context of digital lenders. Digital lenders, as it is, are subjected to RBI's digital lending norms. So, in terms of this law, in what way does this law bring more regulations or more discipline to digital lenders than what is there in the digital lending guidelines? Or are you saying that as far as digital lenders are concerned, RBI guidelines is all that would be required? Is there any additionality that you can think of in terms of these guidelines?
All right, sir. So when it comes to digital lenders, they already come under the purview of the digital lending guidelines published by the RBI, and there are quite strict requirements under the digital lending guidelines when it comes to collection sharing of personal data of the borrowers. There is also the requirements of grievance redressal under the digital lending guidelines. But when we look at the DPDP bill, there are certain additional aspects. So one is with respect to the grievance redressal itself. So although digital lenders may have their own grievance redressal mechanism, however, the DPDP bill says that for escalating a grievance, the data principal who say is a borrower of the digital lender may approach the board, the data protection board. So the data protection board acts as an additional escalation mechanism other than the let's say the GRO, the grievance redressal officer, or the ombudsman of the RBI. Of course, at the same time, the DPDP will also state so that the data principal has to exhaust the recourses made available by the data fiduciary, that is the digital lender. So where the issue is being handled within the grievance redressal mechanism provided under the digital lending guidelines, the data principal cannot approach the board. However, if the data principal does not get an adequate redressal or his grievance is not addressed, then the principal is well within their rights to approach the board, and the board then can initiate action against the digital lender.
Shubhajit,
So,
just to add,
sure, sir.
the stress or the stance of the RBI in digital lending guidelines is the control of the lending activity of lenders. RBI is essential. RBI is not a data privacy regulator. RBI is, after all, lending regulator. It's a central bank of the country. And therefore, the penalties, if at all there's a breach of digital lending guidelines, the penalties imposed by the RBI. This one is coming more like a fundamental right. Data privacy is fundamental right, and therefore, if there is a breach of the provisions of this law, even though it might be coming under RBI's digital lending guidelines too,
Yes.
the you mentioned about the forum for redressal is quite different. And number two, the penalty regime takes you to
Yes.
250 crores,
Right,
which
sir.
I don't think will be the RBI's scale of penalties in any case.
Absolutely correct, sir. That is
Right, right.
absolutely correct. At the same time, I mean, it is not like the RBI has washed its hands of data protection and data privacy, because there is a section within the digital lending
Absolutely.
guidelines which deals with
You're
technology.
right. The RBI is well covered the data privacy, data parting issue. And it talks about GRM as well, but the stance of the RBI is not data. The stance of the RBI is fair lending practices when it comes to digital lending. This one is completely focused on data privacy and handling of data by the processors.
Right. So there is one more point that that I would like to make is, in certain cases the RBI's digital lending guidelines as it applies to digital lenders is stricter. For example, if we look at the data localization laws. So RBI says that financial data or personal data of the borrowers can only be stored within servers in India, whereas the DPDP bill says what it says is it authorizes the central government to prepare a blacklist or countries or jurisdiction where the data cannot be saved. So this is one, and there is also, I think, there's also another part that, sir, you touched upon, where you spoke about consent and certain legitimate uses. So the DPDP Act permits both, as in either the data processing happens under explicit informed consent, or it happens under certain legitimate uses, which we can think of like a deemed consent scenario. But the deemed consent scenario is not covered under the digital lending guidelines. If you collect or process personal data of the borrowers, it has to be under explicit prior consent.
Very important point. And therefore, I think what we're saying is that going forward, you need to comply with both. And obviously, both will have
Yes.
different conspectus of compliances, but you need to be complying with the stricter of the two, and you need to be making sure that you're within the fold of both. Abhirup, while we are on the issue of digital lenders anyways, so let's talk about the so-called fintech lending entities, the fintech lending platforms, not necessarily lenders, but those who assist fintech lending, those who process borrowers' data. And I think one of the important, I would say, mainstays of the fintech lenders has, once again, when I say fintech lender, I'm not necessarily meaning lenders, those who provide services to fintech lenders. Their mainstays has been that they have gone beyond the traditional methods of credit evaluation. They can use all kinds of social media networks and social behavior of the individual, etc., for profiling the credit profile of the individual. And they have their own so-called proprietary algorithms for doing the data for the credit profiling. Under the law, any of the data which is processed by these so-called alternative lending processors, in what way will they be impacted by the law, Birup?
Right. I mean, it's a very, like you mentioned, it's a very common practice for, I mean, that is kind of an USP that a lot of fintech players offer these days. I mean, they create some kind of a proprietary model where they themselves track potential customers and create a borrower profile before they even take it to the lenders. So that gives a flavor about the. I mean, they could be multiple. I mean, it could depend on multiple factors. The model could depend on multiple factors. Now, if we were to look at the kind of information they utilize for creating these models, I can probably segregate this into three parts. Number one, publicly available information. So maybe some of them would have an algorithm which tracks customers' public social media posts, like on Facebook or other similar platforms on LinkedIn, and based on that they could generate some kind of a borrower profile. I mean, we have seen in the past a lot of these algorithms predict based on the checkings they do on social media. They kind of try to determine their spending habit. So with respect to these kind of publicly available information, the bill, so these the any information which has been posted publicly by a data principal is beyond the scope of this bill. So if we look at the applicability of this bill or the applicability of this law, it says that any information which has been made publicly available directly by the data principal is beyond the scope of this law. Also, if the data is being made publicly available by such institutions which are mandated to do such under law, is also excluded for the purposes of this law. I mean, it's also excluded from the scope of this law. For example, I mean, there are a lot of information utilities, a lot of information repositories which require, I mean, for example, NESL or information utility under IBC. A lot of lenders, I mean, the lenders are required to submit a lot of personal data to such information utilities, and anyone who has access to such, who has a login in such information utilities can easily access the data and probably create a customer profile based on that. So long we are relying on publicly available information, there's no problem because it is specifically excluded from the scope of this law. Now, taking a step further, we have seen, I mean, a lot of these players also rely on some private information like, text messages, their debit alerts, bank statements, GST. Now, these are very confidential information, right? So, in any event, if one has to access, one has to gain access to such kind of information, one would quite naturally require the consent of the borrower. I mean, even if it is, I mean, irrespective of whether it is being pulled from the email ID of the borrower, or whether it is being pulled from the mobile phone of the borrower, irrespective, one has to take a consent. So probably that is something which needs to be regulated. If I mean, and properly, I mean, as the law suggests that for such kind of consents, one has to give a notice with the requisite information as provided in the law, and only then one can access it. So therefore, public information, no problem. Private information, it's a consent-based approach. And then there is a third kind of information. For example, drawdowns from credit bureaus, right? We also will create also create our credit profile, customer profile based on the information provided by credit information companies. Now, once again, under the existing law, a lender cannot access a customer's profile unless a specific consent is obtained from the borrower. So therefore, even for credit bureau checks, one has to take a consent from the borrower, and only then they can go and avail the information. So therefore, if I were to summarize the entire discussion for the fintech lenders now, for if they are relying solely on publicly available information, there is no problem. If they are also using private information, they would certainly need a consent, and it would fall very much under the provisions of this law.
Just a small additional question. The social media profile of an individual, for example, there's a private part, there's a public part. One which is available to public, and then one which is accessible only if I've granted explicit consent.
Correct.
So if I want to access someone's, let's say, a social media profile which is non-public, there again I'll need to consent anyway.
Absolutely. Absolutely.
So what you're basically saying is that for accessing someone's private portion of public social media post, as also the GST returns or IT returns or any of the bank statements or any of the even credit bureau information, you will be requiring an explicit sanction of the individual.
Absolutely.
Otherwise, whatever he provides to you by way of a loan application form, that's all you can rest on. If you do your own, extraneous checks, it has to be based on the. What about checking with another co-lender? If I want to check with other co-lender where the borrower is borrowed from?
So, like you mentioned during the introduction, I mean, if so, co-lenders, probably both the co-lenders among themselves will be treated as data fiduciaries. So, if my objective is to share the personal information with another co-lender, then probably, I mean, ideally, I should also take a written consent or an express approval at the time of the loan application, because I mean, I don't think that would fall directly under legitimate use. Let us put it this way. So there is lender A and there is lender B, right? And if the borrower is made aware that there will be two lenders in the process, then it is very fine, and the lender and the borrower is making an application or loan application to both the lenders together. But let's say the borrower is not made aware of another co-lender. Let's say a case of a discretionary co-lender, right? Where at the time of making the application, the borrower knows only one lender, but subsequently another co-lender might come into the picture, and as a part of the arrangement, co-lender A has to share the information with co-lender B. So for such kind of arrangements, I think the lender which has an interface with the customer should take an explicit approval at the time of application, that if subsequently I have to part with information, then you give me your consent for that. Even for example, not only co-lending, even for example, direct assignment transactions or securitization transactions, there might one co-lender has to share information with others. So all these will have to be properly captured at the time of issuing the notice, and a consent should be taken.
Could this notice be a part of the application form, or do you think the notice will have to be separately drawn? For example, when it comes to co-lending, quite often, and in fact, I think more often than not, the name of the co-lender is not known at the time of giving the loan, because it's always subsequent that I can have a consent that I will be getting a loan participation from someone else, but which lender will I be getting the participation from? That is something that I don't know at the time of granting the loan. Likewise, in case of a so-called direct assignment, I know that I might be doing a DA, but which entity will I do the DA to? I wouldn't know. So, Shubhajit and Nabiru, both of you, is it possible to incorporate these consents? Of course, the consent will still have to meet those specifics. It has to be unambiguous, it has to be unconditional, free, fair, etc., all the qualifying conditions. But does the consent have to come as a consent or can be embedded as a part of the loan agreement or the loan application form so that we're not necessarily talking about a separate document called consent letter? Both of
Right,
you.
sir. Right, sir.
Yeah,
Which,
please.
who?
For
Yes,
this,
Shubhajit, yes.
yeah, but for this case, I think we need to see how the ecosystem evolves as well, because there is the concept of the consent manager, which is also raised in the bill. So how the consent manager will play its role in terms of managing consents. So the consent manager acts on behalf of the data principal. The consent manager would then have to manage consent, including the provision of consent as well as the withdrawal of consent on behalf of the data principals. So we would have to look at how the ecosystem ultimately emerges in terms of managing consent. But having said that, given the information that we currently have, um, the consent should be taken. There is basically the requirement of the notice, and in the notice there is requirement of certain content in it, including the data principal's rights, the right to escalate to the board in terms of grievances. So as long as the contents of the notice are well incorporated into the application form or the loan application, and the data principal is made aware of the rights that he has under the bill. I think it should also work. However, I think we should wait for how the ecosystem emerges in terms of the overall consent management system.
That's an important point. And Abhirup, are you wanting to add anything to
Yeah,
this?
I
Or
want
yeah,
to add
okay.
something. Yeah.
Uh-huh.
So, I mean, like Shubhajit mentioned, I mean, it can be made a part of the entire application. But I mean, given the importance of notice in the present case, I think it should be, made reasonably clear, or, I mean, it should not be something like a hidden consent. We have seen, I mean, pages and pages of consents that I mean, a lot of apps ask for these days. So I think it should be made pretty much clear and reasonably visible to the customer, to the data principal, because I mean a lot of the provisions or the lot of the operative provisions of this law depends on the notice. So yes, it has to be made absolutely clear. Now coming to the second point, because you mentioned that at the time of giving the loan, probably I don't know with who I want to share the information in the due course. Like they could be, I mean, 6 months down the line, there could be a lender who comes into the picture by and wanting to buy the receivables. I mean, I might have to share that. I cannot foresee like there will be a transaction 6 months down the line. So probably I think we can make it. I mean, we can incorporate that this is a part of the specified purpose itself. That I mean, in the due course, the company, the lender might engage in assignment or securitization transactions, and in the process, it might have to share their information. Also, the data principal has a right to ask for the names of the parties with who the information has been shared by the data fiduciary. So even if 6 months down the line, I mean, if we are not being able to disclose the name in the very first instance, the data principal still has the right to find out with who we have shared the information subsequently.
I think this point itself raises several complicated questions. And if you were to think of, let's say, even a loan transfer, the so-called direct assignment or loan transfer business, which obviously happens much after the loan has been extended. So it might even be that for the loans already given, we might be transferring the loan subsequent to the enforcement date of the law. And if we are saying that the sharing of the data in that case cannot be done without explicit consent, and the consents, and I'm coming separately to the retrospectivity part, whether consents already taken would still be valid after the law becomes operational. But before I come to that, what am I sharing? I'm sharing the loan performance data. I'm sharing borrower's name, borrower's identification number, which is my identification number. I'm sharing how much loan the borrower has taken against what purpose, and how has the borrower been performing. I'm sharing the borrower's performance data when I would like to transfer the loan to some buyer. So how do we identify the information which is forming part of my loan records? Is it borrower's personal data or is my personal data? I'm the lender. The performance of the loan is performance as to me. So where am I transferring the borrower's personal data?
Okay. So I mean, I think we can, let us. There could be two types of cases where I'm along with the right to receive cash flows. I'm also transferring the servicing function to the uh, uh, incoming or to the assignee. In such cases, anyway, we have to share the personal data relating to the borrower, because without that, they'll not be able to carry out the servicing function. So if we are doing that, then yes, of course, it would fall within the purview of this law. But if we are just sharing, I mean, if we are retaining the servicing and we continue to interact with the borrowers, and we are just transferring the performance data, I think we can take a much liberal view and say that it is still outside the it is actually we are not transferring any personal data, because
I get a
personal
point.
data,
I get a
yeah,
point, but this will obviously also be a part of the subordinate law, probably clarification from
absolutely, absolutely,
Data Protection Board.
absolutely.
But think of it as this, like, what am I actually doing? One data fiduciary is transferring data to another data fiduciary, as the second data fiduciary now becomes the holder of the loan receivables. And therefore, to the extent the data was given voluntarily for a legitimate use to the first data fiduciary, the first one transferring to the second one, which is also a DF and is therefore subjected to all the regulations applicable to a DF, should not require or should not be subjected to any specific discipline of the law. Because if that was the case, every time I do an assignment, I need to get a borrower's concurrence for sharing the data. Particularly for lenders, that would be formidable. But to my mind, I think none of the provisions of this law will lead to impracticality of the way in which business currently works, be it loan transfers, or be it securitization, or be it co-lending for that matter. Shubhajit, on the consent, because let's say most lenders do cross marketing. Data of a borrower was shared by the borrower for taking a loan. And most of the lenders currently have some kind of mutual fund, some kind of insurance agent, some other entity. Most of that financial entities currently are using that data for cross marketing as well. So if the lender has taken consent of the borrower for using his data for cross marketing, and the consent was taken prior to, of course, the enactment or prior to effective date of the law, what happens to those consents? Will the consents going forward still remain valid once the law comes into operation, or do you think a separate consent mechanism for all the previous consents will have to be put in place? Shubhajit.
Right, sir. So, as we have seen on under Section 7, there are two ways in which data can be processed by the data fiduciary. Either it is under explicit consent or for certain legitimate use. Now, when we talk about lenders using the data for cross-selling, say for mutual funds or insurance, obviously we can scratch off the legitimate use clause, because the certain legitimate use clause says that the data principal has voluntarily given you the data and for the specific purpose of the data principal. So in this case, let's say the data principal has approached you for the purposes of lending and not for the purposes of getting an insurance or a mutual fund. So we can scratch off the legitimate use case. Now, so if you engage in cross-selling of data, you would need an explicit consent from the data principal or the
Explicit
borrower.
new consent is saying. And
No,
not
so I'm just saying, if you have, so under the DPDP, under the DPDP bill, it puts an obligation on you to get an explicit consent. Now, let's say you have taken explicit consent before the commencement of the bill to cross-sell, right, to share the data with some of your partners. But the DPDP bill goes on to state that even when you have taken explicit consent before the commencement of the bill, you will still need to serve fresh notice to the data principals from whom you have taken such consent. The bill does not say that you will need to retake consent. It says you need to publish a fresh notice, and this consent that you have taken prior is subject to withdrawal of consent from the borrower. So let's say after the commencement of the will, the borrower is within their rights to withdraw the consent to process the data, for the lender to process the data for cross-selling or promotional purposes.
Right. Let's come to the other part, which is also quite significant. The bill says that once the purpose for which the data was shared, be it on the basis of an explicit consent or be it for legitimate uses, once the purpose is over, the data will have to be erased. In case of lenders, when does a lender say that the purpose for which the data was given is over? And therefore, when is a lender expected to erase the data of the borrower? I don't know, Abhirup, you would like to answer, or Shubhajit, whoever would like to answer this.
Yeah, I think Shubhajit can go ahead.
Shubhajit?
Oh, okay, sure. Again, like if we look at the provisions of the DPDP bill, there are two cases, two discrete section, two separate sections in which erasure of personal data needs to happen. One is the one which sir you just mentioned about the fact that either the purpose for which the data was provided is over, or if the data was provided under consent, that consent has been withdrawn. So whichever is earlier. However, at the same time,
You said whichever is earlier.
that is correct, sir. Whichever is earlier.
To make the question more specific, let's say I have a running loan and the borrower is given me the data for the purpose of running loan. He withdraws the consent even before the loan has been serviced.
Right, sir. So in this case, sir, since it's whichever so the withdrawal. Okay, now we again have to go back to section 4, because section 4, the data can be given under two cases. One is either consent based or legitimate use. So when we are talking about a running loan, we are talking about legitimate use, because the data was voluntarily given by the borrower for the purpose of taking a loan. So once we talk of certain legitimate, once the transaction falls under certain legitimate use, the withdrawal of consent portion becomes inoperative.
In fact, we'll also have to read it with section 17(1)(a), which says neither of these sections will be applicable if the processing of data is required for enforcement of legal rights. So if I'm given a loan, I have a right to recover the loan. Therefore, no matter the borrower withdrawing the consent, the whole basis on which lending industry works will collapse if the borrower, even before repayment of the loan, was to withdraw his consent. But Subhajit, on a focus question, assuming the loan is fully serviced, fully repaid, in that case, am I required to erase the data, or do I need to retain the data for X number of years? KYC norms, I guess, require some retention of data.
Right, sir. So we look at section 12 in the DPDP bill. In section 12, it also talks about the right of the data principal to request erasure. But it also speaks about regulatory or legal requirements upon the data fiduciary. So if the data fiduciary is required to retain the data for a longer period of time, or retain the data even if there is a request from deletion from the data principal, the data fiduciary shall continue to do so. So now digital lenders would come under, like the regulated entities, the regulated lenders under the RBI would come under the purview of PMLA as well as the KYC master directions issued by the RBI. And in there, if we look at the sections on the paragraphs on the maintenance of records, it says that both transaction data as well as personal data of the customer needs to be stored for at least a period of 5 years, either from the date of the transaction or date of the relationship.
So in this case, the date of relationship will mean the date of full repayment of the loan. 5 years after the repayment of the loan, I need to actually, the question is not I need to erase the data, but the erasure will be 5 years after complete satisfaction of the loan transaction. Abhirup, do you want to add anything at all, or you're okay with this?
Yeah. Nothing from my end to add over here. Yeah.
So now the question next would be, and Abhirup and Shubhajit or whoever is assisting us can also see the question from the participants. If any of the participants participating in YouTube or those who have given us questions before we started this. Are there any questions at all from the participants? Please be on the lookout. But in the meantime, retention of personal data. Now, once again, I think we talked about handling of data breaches. Shubhajit, the data fiduciaries need to have an elaborate and explicit mechanism for safeguarding the sanctity of the data, retention of data, making sure that there are no data breaches. So, in your understanding, what are those, intangible measures that lenders will have to put in place? That includes, a traditional banker as well as a fintech lender, any traditional as well as non-traditional lender. What are the specific measures for protection of data that lenders will have to ensure to be in line with the law?
Okay, sir. Like before I answer that question directly, what I would like to say is that the DPDP bill in itself, like any other act, does not specify any specific uh, information technology or cybersecurity requirements upon the data fiduciaries, but it places a very high penalty if there is a data breach. So it is around a 250 crore penalty that is specified in the schedules. This is number one. Number two is the DPDP bill also differentiates between a regular data fiduciary and a significant data fiduciary, right? And if let's say a category of entity, an entity or a category of entities is prescribed as a significant data fiduciary, there are some information technology requirements that are prescribed by the bill. One is the appointment of let's say a data protection officer. Then there is the question of the data impact assessment. And thirdly, it also provides requirements to have periodic IS audit. Again, NBFC's lenders, especially those falling in the middle layer or upper layer, under the scale-based regulations, they are already under the information technology framework for NBFCs as prescribed by the RBI, and that framework has stringent requirements upon lenders. Also, there is the draft information technology requirement, which is an integrated requirement across lenders, be it NBFCs or banks or AIFIs. So that has even more stringent requirements as to data protection, change management, etc. So when we come to the data protection bill, just to summarize my answer, it is not that it has provided specific requirements upon the let's say the data fiduciaries with regards to information technology. However, saying that, there is one important aspect that we need to mention, that is about if a data breach actually happens. So if a data breach actually happens, currently under the information technology framework prescribed by the RBI, certain cybersecurity incidents have to be informed to the RBI by the lenders. Also, there is requirement under the Information Technology Act, the cert.in regulations, where you also need to inform the cert.in authorities. Now, coming to the DPDP bill, there is now another requirement where you will also need to inform the board as well as provide individual notices to the data principals whose personal data was affected by the breach.
This is tremendous. You are saying in case of certain, the so-called certain information, I'm talking about cybersecurity breaches that get filed with the certain authorities. Here you are saying that if at all a data breach has happened and my data has been hacked and let's say taken away by somebody, I need to inform the data protection board, I think, which is also one additionality. But talking about informing each of the principals, so the first thing would be to determine which all principals data has been taken away, and then I need to inform each one of them that your data has been compromised. While this is, I would say, it's a formidable requirement, but we are aware that in the past, from the possession of financial institutions, data pertaining to lakhs of borrowers have been taken by ransomware attackers, etc. And therefore, this is a completely new dimension. But I think, Shubhajit, you talked about significant data fiduciaries.
Right.
And we need to watch out as to who will be significant data fiduciary. I'm sure number one will be on the size. The so-called big techs will probably all necessarily be significant data fiduciaries. I'm not sure whether commercial banks also would probably be, because commercial banks are repositories of so much of data pertaining to individuals. That apart, I would imagine credit card issuers might also. I mean, these are things that we need to see how the law pans out, how the rule making under the law pans out. But I'm not expecting NBFCs, even though they are so-called upper layer or middle layer entities, to be notified as significant data fiduciaries. I don't know whether you would see that possibility under a group. Would you see larger of the NBFCs being notified as SDFs,
Uh,
or this is just a
One
guess as
thing,
of now?
yeah, I think it's a guess as of now, because I mean we will have to. I mean probably it will. The central government will come out with a list of SDFs, but if not NBFCs, I can surely see credit information companies forming part of that list, because given the amount of data, amount of personal data they possess. But among NBFCs, I mean, there could be a few upper layer NBFCs having, I mean, mostly dealing in the retail segment. The ones dealing in the retail segment, I mean, they could also feature in that list, but it's completely a guesswork at this stage.
But therefore, people who have massive personal data of a lot of people, I think those will be where the SDF
Right.
notification might come, imposing additional obligations on entities.
Yeah.
Shubhajit, coming to the concept of consent manager, we have talked about that earlier, but this is a part of the ecosystem, and we need, once again, we need to see how this concept of consent manager develops. So, Shubhajit, two questions. Number one, under the general data protection regulations of European Union, do we have a similar concept at all? Part one. Part two, what do you think will be the shape of the so-called consent manager? Is it an entity through whom can a data principal, for example, say that I will give my consents only through a consent manager, and therefore whatever I've given earlier in the past, I would withdraw all of them, but I will give it through a consent manager. So is it like, is it something that a data principal can force upon a data fiduciary, or will it be consensual between the two of them? So Shubhajit, two questions to you, and a group, in case you would like to pitch in, please do feel free.
Sure. Sir, for this purpose, again, we need to look at the language of the act, especially under subsection 7. So where it says that the consent manager is accountable to the data principal. It also says that the consent manager acts on the behest of the data principal, and the bill provides the data principal the right, that is, the data principal may exercise his consent or withdraw his consent or manage it any other way via the consent manager. So from this plain reading of the bill, it appears that the consent manager is an additional option for the data principal to provide consent. I mean, not I mean, the data principal can directly provide consent to the data fiduciary, or he may opt to use the services of a consent manager. So this is my reading of the bill. Abhishek sir, if you would like to comment.
No, I mean, I mean, this is once again a guesswork. I mean, we will have to see how certainly will be a subordinated legislation for consent manager, and that's exactly what is being provided in the bill as well. That who can be consent managers and probably their rights and responsibilities, or how the framework would work. I think we will have to actually wait for the subordinated legislation to get a clearer picture. But as you mentioned, yes, looking at the language of the law as it stands, I second your thoughts, whatever you mentioned.
There's quite a basic question, and though, of course, basic question is a very interesting question, asking personal data. Does it relate to data of any person, or, for example, even a company? Can a data pertaining to a company also be said to be personal data? I think the answer lies in the definition of personal data itself, very clearly defined in the law. And if you look at definitions, personal data means any data about an individual. It's not use the word person when it comes to data. The word is personal data, but not the word person has a very wide definition. But personal data is restricted to an individual because this is what the Supreme Court took as a fundamental right. And fundamental rights, of course, are only for citizens of India. So it's number one, persons, and number two, I think the individual has to be, sorry, an individual. And I guess it's only an individual who is citizen of India. Someone who is not citizen of India, I cannot claim any fundamental rights in the country.
Yeah.
That's not explicitly so very defined in the law, but I guess that would be the limitation. We're talking about individuals who are citizens of this great country. Are there any of the questions, Aviroop and Shubhajit, that are, raised by our participants participating today, or the questions shared by participants before, and or people who are participating currently? If you have any questions, there was a question asking specifically about compliances for microfinance entities. Microfinance entities, of course, collect whole lot of data about whole lot of borrowers. And therefore, if MFIs are using this data in any form, for example, cross-marketing, they can definitely use the data for the recovery agents. There's absolutely nothing wrong in sharing the data to a collection agency, because that's very clearly captured by 17(1)(a) and 17(1)(f) in the event of a default. But other than that, if the microfinance entities are using the data, say to once again, if the lender is giving the data to his, let's say microfinance lender is giving data to its own lender, but that's also data being transferred by a fiduciary to another fiduciary as a part of legitimate business. So I don't think that would be objected to. But if the MFI is using the data for any kind of cross marketing, then the consent would be required. And my colleague Shubhajit says that a fresh notice after the law becomes operational would still be required. I think
I
that's the
think
question.
one follow-up question on this could be like, what if, we said that if we are using personal data for cross-marketing, then of course that should require a consent from the customer. But say, for example, if there are cold calls or cold emails sent as a part of your marketing, there could be, so there could be two types of marketing. One are generic marketing and one which is targeted marketing, which means, for example, I know for the fact that based on, so Mr. A has obtained a consumer durable loan from XYZ Limited, right? And based on that, the lender, uses the data, uh, sees how the customer is performing, and does targeted marketing and offers, let's say, a personal loan of say 5 lakhs, right? Now, very clearly, the lender has utilized the personal data of the customer, and based on that, the entire marketing exercise was done based on the processing of the personal data. But so I'm sure, you both can confirm, but I'm sure, in such cases, even for such kind of marketing, I must have taken a consent of the customer. But what if this is like a generic email blast that I'm doing, and that could reach to like a lakh customers at once? Will that also be a part of this consent requirement?
I think we lost you for a few seconds, Abiru, but I'm understanding still the question that you're asking, and I think very pertinent question, because I think that's exactly where invasion into someone's privacy is happening. And I think day in and day out, you get all kinds of pesky calls about offering loans and offering credit cards and offering whatnot, which is obviously by people presumably acting on behalf of some bank. They go to the extent of saying, "आपका फला branch में account है," which means obviously the information is passed by my banker. To my mind, this is very clearly an invasion into privacy, and I think this bill very clearly, that's exactly what I think the Supreme Court was aggrieved about. And to my mind, this is very clearly hit by the law. So a cold calls or kind of a generic email blast, it's still it's invades into your inbox. It either comes into your cell phone or conveys into your inbox. So to my mind, I think I would like to hold a view that this is definitely intrusion into my privacy. We are almost going to be about 1 hour, and if there are no further questions from the participants, I don't think there is any specific question as of now, but let me say that this is a wonderful law, and the fact that it is almost close to the day when we celebrate the independence day of this country, it makes it even more significant, because it's a reinforcement of a very, very fundamental right that
Yeah.
all citizens of this free country need to have. And therefore, I wish that this law soon gets implemented, And I'm not sure how much privacy we'll continue to have, because we're all slaves of the tremendous network which continues to be watching us all the time. If not this law, probably someone at some stage is keeping watch. All your transactions are on a GST portal. All transactions are before the banker. Every banker is examining whether any of transactions done by suspicious transactions, and so on. So we are on watchful eyes of so many agencies of the state which are anyway exempt from the law. So to that extent, our privacy is subject to attack all the time. But hopefully, at least some relief to individuals and some protection of fundamental rights. But for lenders, of course, it means a little more of a burden, despite the specific provisions of the RBI on digital lending. And I think with this, once again, thanks everyone. Thanks both Abhirup and Shubhajit. And thanks to all our participants who are present today or who would be watching this Shastras ever in future. Thank you very much and wish you all a very, very happy Independence Day.
Thank you so much.
Thank you, sir. Thank you so much.